Good afternoon to everyone. And my name is Sangram Satish Jadhav. I'm a assistant professor working at Government Law College, Mumbai. Before GLC, I was at Maharashtra National Law University, Mumbai, and I will be we will be discussing today about check bouncing cases and more particularly about Section 138. So, just to start with this topic, uh, one must understand that this is regarding check because the as the titles suggest, the title is of penalties in case of dishonor of certain checks or insufficiency of funds in the account. The first thing is that it is applicable to check. Therefore, it is also important to understand what is check and why this dishonor of check has been made a punishable offense. So the thing is that now, first, we all know, let me tell you that check is governed by Negotiable Instrument Act of 1881, right? So this Negotiable Instruments Act of 1881, it recognizes only three kinds of negotiable instruments. First is your check, bill of exchange, and promissory note. Section 4 of the Act deals with promissory note. Section 5 deals with bill of exchange, and Section 6 deals with check. And the fundamental rule, the basic thing is that all those negotiable instruments, please understand that these are not the only negotiable instruments we have. Okay, even money, even currency note, hundi, even government securities, they can be considered, they are promissory notes, they are negotiable instruments, they can be considered as negotiable instrument. But this law only recognizes only three types of negotiable instruments. So as far as this check is concerned, check is nothing but a contract between the parties. So we all know this check is nothing but a bill of exchange, and it is made payable upon a banker. So in check we have three parties. That is the customer first. He is considered as a drawer. Second is your bank, that is drawee, and the person to whom the payment is made is called holder or the payee. So please understand, check is a contract. Bill of exchange, as I said, check is nothing but a bill of exchange. Bill of exchange is a contract. Even promissory note is nothing but a contract. It is nothing but a contract. And if there is a dishonor of check, that is nothing but a breach of contract. And that is why first primary argument is that this dishonor of check is nothing but a civil wrong. It is nothing but a civil breach of contract. And that is why in this Negotiable Instrument Act only, we have provision in case of dishonor of check. We do have civil law remedy. So this is Section 30, which is there on your screen. Section 30 of the Negotiable Instrument Act, which says that if the bill of exchange or check is dishonored, then this holder uh, this holder can claim compensation from the drawer. That is Section 30. And the thing is that this Section 138, as I said, this contract, this is a like this sort of check is this is a breach of contract. It is a That is why we have similar remedy for the same. And as far as the liability of the third, like the draw is concerned, bank is concerned, we do have one provision, that is Section 31. Section 31 is that if the check is dishonored due to due to the fault of bank. So suppose if the drawer has a sufficient funds in his account, but if the check is dishonored, then this Section 31 comes into picture, which prescribe punishment for the bank. So in this case, it deals with the liability of the drawee of the check. So in this case, the drawer has a right to claim compensation from the bank. That is, the customer will claim compensation from the bank, because the holder cannot claim compensation from the bank because there's no direct relationship between them, right? And that is due to the privity of contract. So the interesting, now we will start with the topic, actual topic. So the topic is punishment, penalty in case of dishonor of check. Let me tell you, before 1988, okay, as I said, primarily this is a civil wrong. Okay, because this check is nothing but a contract. Bill of exchange is nothing but a contract. That is why this is a civil wrong. And this is nothing but a breach of contract. So before 1988, we used to have only civil law remedy in such a case. Okay. But the thing is that in our business transactions, check is being frequently used as an instrument. And that is why if there is a dishonor of check, there's a dishonor of check, it sort of discourage traders and businessmen for dealing with it. That is why to enhance the credibility of this instrument, that is check, it was thought in 1988 to make it a penal provision, to make it a punishable offense. Because we all know the object of criminal law is to create deterrence in society. That is why, please understand, this is a civil wrong. This is a breach of contract. This breach of contract, it was made punishable by this section 4 of the Banking and Public Finance Institution and Negotiable Instrument Laws Amendment Act of 1988. And then it was made a punishable wrong. And this chapter is the 17th chapter of this Negotiable Instrument, the last chapter of the Negotiable Instrument Act. This chapter, uh, which which has made this check bouncing case as a punishable wrong, it came into effect from 1st April 1989. So this is a civil wrong, but it was made punishable uh, since this 1st April 1989, because we all know that it is very difficult to get civil law remedy, because we all know civil litigation is a very time consuming process. So if you see, uh, the remedy, the civil law remedy in case of check bouncing cases is section 30 of the Negotiable Instrument Act. And thereby, like by invoking this provision, one may file a suit for recovery of money. And you have one more option if you want to exhaust your civil law remedy. The option is, uh, if you read Order 37 of the CPC, it is a matter which is summarily triable by the civil judge. Therefore, a summary suit can be filed to speed up the process. But again, that is a very time-consuming process, and just to create a deterrence in society and just to enhance the credibility of the instrument, that is check, it was made punishable by the section 4 of this Amendment Act of 1988. Now, uh, the thing is that when it was made punishable in 1988, many persons, many scholars, they criticize this amendment, saying that in our penal law we do have a provision in order to deal with the situation, that is check bouncing cases, and that is offense of cheating. So this is 415 of the IPC, and now we all know we have new criminal code, that is Bharatiya Nyaya Sahita. This is section 318, clause 1 of this Bharatiya Nyaya Sahita, and this is the offense of cheating. It has been claimed that if the drawer issued a check in favor of person, and if the same is dishonored due to the insufficiency of fund, then the thing is that a person can be charged for the offense of cheating. And that is why there was no need uh, in 1988 to insert this chapter. But the counter argument is, so we need to understand this. There is a counter argument. There is a reason why it got introduced instead of having this law at that time. So the reason is, please understand the difference between cheating and 138 cases. If you read this definition of offense of cheating, here it is mentioned that whoever by deceiving any person fraudulently or dishonestly induces the person so deceived to deliver a property. Please understand the essential element of cheating is deception. That is mens rea. Mens rea, it is required to constitute cheating. Please understand this. This is a basic principle of criminal law, that actus reus and mens rea, they are required, they are necessary to constitute any wrong, including the offense of cheating. But if you read the section 138, that is different. So let's discuss 138. Now this is section 138. If you read this section 138, you will understand that in order to constitute this wrong, mens rea is not required. Guilty mind is not required. Please understand this. In this section, strict liability is imposed. So if you read this section, where any checks drawn by a person on a banker for payment of any amount of money to another person for the discharge of debt or liability, if it is written by the bank as unpaid because of the amount of the money standing to the credit of that person is insufficient, then such a person shall be deemed to have committed an offense. Please understand this. Such a person shall be deemed to have committed an offense. It excludes mens rea from it. Right? This section, it imposes strict liability on us. So please understand this. Mere fact, mere drawing of a check, okay, that can amount to this wrong of 138. If the check is drawn by a person and if it is dishonored due to the insufficiency of fund, then this fact is sufficient to constitute wrong. That is wrong of 138. But that is not the case with 415, that is offense of cheating, or 420, right? So we do have one more provision which deals with cheating apart from 415, and that is 420. So we all know the difference. I will tell you the difference because that is also very important for us. So 415, it deals with cheating. Okay, as per the new Bharatiya Nyaya Sanhita, it is 318, clause 1. It says that whoever will try to deceive any person, okay, to induce that person to deliver property or to consent to any person that such a person shall retain the property or anything like that, that amounts to cheating. So 415 defines offense of cheating, but 420 of the IPC, that is 318 clause 2 of the Bharatiya Nyaya Sanhita, that says that deals with successful cheating. Okay, if due to that deception created under this provision, if any property is delivered or damaged or destroyed or altered in any form, then that is considered as successful cheating. And 420 is more punishable. It is a grave offense. It is a considered a serious offense compared to 415. And this 420 of the IPC has found its place in Bharatiya Nyaya Sanhita as well. That is clause 2 of section 318 of this BNS 2023. So the thing is that this successful cheating, which we can call it as successful cheating, okay, it is considered as a serious offense because that is something which is punishable with a 7-year imprisonment, right? But simple cheating is punishable with 1 year imprisonment. So that is the difference. Now, to constitute both this offense of cheating and successful cheating, right? What is required? Mens rea is required, right? So please understand this, that mere drawing of a check, right? It will not amount to a representation by drawer that he had a sufficient knowledge about the insufficiency of fund, right? So the element of deception cannot be inferred, right? In this case, because 138 cases, they are different because their mens rea is not required. So this deception cannot be inferred, right? So in order to constitute the wrong of cheating, mens rea is required to be proved separately. Another, let me tell you the other reason. The other reason behind this amendment was that at that time, so we all know this simple cheating and this successful cheating, it is governed by a penal law, right? General criminal law. And there we follow the rule that the prosecution is supposed to prove his case beyond reasonable doubt. And the accused is presumed to be innocent unless proved guilty, right? That is why it was extremely difficult for the prosecution to discharge this heavy burden. And that is why the conviction rate, if you see, the conviction rate in IPC is very low. The conviction rate for cheating, right, it is very low. It was very low at that time. And that is why, due to these things, uh, it was thought that apart from cheating, we should have one law, or we should have one penal provision for this check bouncing cases. Now, as I said, if you read this provision, uh, here we follow the principle of strict liability. Okay. Now, let me tell you a bit about this strict liability as well. So, please understand. Now, we all know that in a penal law, both actus reus and mens rea, they are required to constitute a wrong. However, it has certain exceptions. Okay. And one of the exception is strict liability. So if you see civil law, in civil law, we follow the principle of strict liability. There, mens rea, my guilty mind, my knowledge, my intention is not important factor. Whereas in criminal law, we follow different rule. So please understand why strict liability has been followed in this case. So please understand, as I said, check is nothing but a breach of contract. And for this breach of contract, we do have a civil law remedy. And this civil wrong has been enforced by a criminal machinery. So there is a rule, this is a basic rule, that whenever a civil wrong has been or is being enforced by a criminal machinery, mens rea is not an important factor. A good example can be maintenance. We all know maintenance to a wife and children. We do have a provision for the same. Even in that case, maintenance is a civil wrong, but it has been enforced by criminal law machinery. That is why mens rea is not important factor, right? Is not an important thing that makes it a offense. So, in the same way, this is a breach of contract. This is a civil wrong, and it has been enforced by criminal law machinery. That is why here mens rea is not required. It imposes strict liability, and that is why strict liability is also called as no fault liability. So now it is important to understand, as I hope like we are clear with the background of this 138, that why it has been drafted in such a manner. Now it is important to understand the features of this 138. 138 is being frequently used in court of law. So it is important to understand the features. This is a very important provision of the Negotiable Instrument Act 1881. And the first feature is, if you all can see, this provision will come into picture or can come into picture only if the check is issued to discharge a debt or other liability. And the first feature, the first condition is that the debt or the liability must be legally enforceable debt. It must be legally enforceable liability. And now, as I told you, that it is easy compared to offense of cheating in general criminal law. It is easy to secure conviction in 138 matters. And that is due to the thing that we have various rules of presumption in this chapter. Okay. So this is section 139, which is there on your screen. It says that what is the first condition? That check must be issued to discharge a debt or the liability, right? It has been presumed, it will be presumed that if the holder received a check from the drawer, it shall be to discharge any debt or liability. Please understand this. This is a mandatory legal presumption. We all know the importance of presumption. The importance of presumption is that it shifts the burden. Please understand this, that no such a rule of presumption is there in our general criminal law with respect to cheating. It is there only with respect to 138 matter. That is why in general penal offense, general penal offense of cheating, it is difficult to secure conviction because there the prosecution, he has to discharge this heavy burden. right? And uh, most of the time, in many cases, right, they are not able to do so, and that is why it is difficult to secure the conviction. But in 138 cases, we do have many provisions for which deals with this rules of presumption, right, which makes it easy as well to secure conviction. So the debt and liability. First thing is debt and other liability. Now this debt and other liability must be legally enforceable debts. It must be valid debt, right? So please understand this, that what is valid debt? What is valid debt? A time bar debt is not a valid debt, right? Suppose if a person uh, if a person has issued a check in favor of another person, right? And now he's supposed to recover his money, right? So he's supposed to recover his money. Like the holder is supposed to recover money from the drawer within a specific period of time, right? So there's a limitation period for the same, right? The limitation period is 3 years. If the debt is time bar debt, right? If the debt is time bar debt, then please understand that such a debt is not valid debt. And even if a check is issued by the drawer in order to discharge a time bar debt, this section 138 will not come into picture, because the first condition is that a check must have been issued to discharge a debt, and that debt must be legally enforceable debt. That is the most important thing. Now, the deeper question is, can we revive a time bar debt? That is the question. Okay. So there are two things to revive a time bar debt. There is one provision, and that provision is Section 18 of Limitation Act. It deals with acknowledgement. And there is one more provision, that is Section 25, Clause 3 of Indian Contract Act, which deals with promise in writing to pay a time bar debt. Please understand the difference. These are the two ways through which we can revive our time bar debt. Please understand this. But there exists a difference. Now let me tell you the difference first, then we will discuss it further. So the difference is, in case of Section 18 Limitation Act acknowledgement, this acknowledgement, it will have the effect of reviving your uh, time bar debt. Okay, but the condition is that this acknowledgement should be made before the limitation period is over. So before a debt, right, before a debt will become a time bar debt, acknowledgement must be made. Okay, whereas in case of 25 clause 3, this promise to pay in writing, it should be made after the debt has become time bar debt. So after the limitation period is over, if the person, if he is willing to make a promise to pay a debt which has become time bar debt, that will fall under the clause section 25 clause 3 of the Indian Contract Act. Otherwise, it will amount to acknowledgement under section 18. That is the difference. Now the deeper question is, suppose if there's a debt between A and B, right? And suppose it has become a time bar debt, so the limitation period is over. But now, see, now the limitation period is over. There legally there exists no duty on the part of the drawer to draw a check in order to discharge the debt, because after the debt has become a time bar debt, a person's right has no remedy. It is considered as an imperfect right, because that is a right without remedy. However, but suppose if the if the debtor suppose if the debtor, that is the drawer in our example, decided to discharge the debt by issuing a check, then the more deeper question is that merely giving of a check, okay, without anything more, can it revive my time bar debt? That is the question. Or should we have a separate contract to revive a time bar debt? That there should be a separate promise in writing to pay time bar debt, separate contract, and then it should be followed by check. What should be the procedure? So please understand Supreme Court has made it clear while discussing 138, while discussing this first condition of 138, that merely giving of a check does not revive, cannot revive a time barred debt. But a debt should be revised first by making a written promise to pay. That is a separate contract. And then a check can be issued in payment of the same. So this is the judgment. You all can read it, right? Uh, so you can refer it. And the ratio is this only, that first there must be a separate promise to pay, and then it should be followed by a check. Then next important aspect of this condition is, please understand this. So as I said, what is check? What is the nature of check? Check is nothing but a contract. It is nothing but a contract between two persons, between two individuals. Now, please understand this, that the essential features of contract is that a contract, the object and the consideration in contract, it must be valid. So if the debt which is bad in the eyes of law, will it attract 138? The answer is no. You can read this case. See, in this case, the respondent, he had paid a sum of money to the accused in order to get his nephew a government job in Haryana. But the money was paid of the promise of securing a job in police service. Now, this object of the contract, the object of this agreement is against the public policy for the purpose of Section 23 of the Indian Contract Act. Now, in this case, the job could not be secured and the complainant asked for the money back. Then the person who received that money, he issued a check, but the check got dishonored due to the insufficiency of fund. And then the complainant, the person who paid the money, he decided to file a complaint before the magistrate. In this case, the magistrate convicted the accused person, punished him. But when he filed an appeal in a higher court, he argued that the debt was not a legally enforceable debt. What is the condition of 138? That a check must have been issued to discharge a debt, and that debt or the liability must be lawful, it must be legal. And in our case, in this case, the debt was not a legally enforceable debt, and that is why he could not be convicted under this section. The court held that the agreement was not lawful, and the higher court set aside the conviction given by a magistrate in this case. So the moral of the story is that the, the first condition is that check must have been issued to discharge a debt, and that debt must be lawful in nature. It must be valid in nature. Then the thing is that what is the first condition? That a check must have been issued to discharge a debt. Now, please understand. Please, I seek your attention on a word which says that any debt. Here, the expression which is used is any debt. It does not mean that the drawer must have issued a check in order to discharge his debt only. Okay. So in this case, a drawer, he issued a check in order to discharge debt of his father, and that got dishonored. Court said this will not make any difference. Okay. Even if that is the case, even if he issued a check in order to discharge the debt of his father, the drawer will be prosecuted for this wrong. Now, so the thing is that this section 138, uh, it will come into picture if the check is issued to discharge a debt or other liability, right? Now, please understand this. Suppose if a check is given by way of gift, okay, and now if the same is dishonored due to the insufficiency of fund, please understand that in that case, in that situation, 138 will not come into picture, because when it will come into picture, only if the check is issued to discharge a debt or the liability. In this case, the in this case, as it has been given by way of gift, that is why this law will not come into picture. right? But now, if you ask me what will be the remedy available in that such case, you understand, if I have given you a check as a gift, if it has been dishonored, you will have civil remedy available with you. You can file a suit for recovery of money from me, because we all know, even a gift, that is nothing but a contract, right? We all know this agreement without consideration is void. Gift is an exception to this section 25, right? Gift is governed by Transfer Property Act, and in order to have a valid gift, we all know, it involves proposal, it involves acceptance as well. Just that it does not involve consideration. So even gift is a contract. It is a contract without consideration. It is made without consideration, voluntarily. And that is why, even if there is a breach of contract in case of gift, then civil law remedy is available. Now, next thing is that next condition for to invoke 138 is check has been presented to the bank within the period of its validity. Now, this is something which is very important. So we all know check is valid for only 3 months. But please understand, this rule is applicable to only 138 cases. Okay. If after the 3 months period is over, if the check is dishonored due to the insufficient fund, then the holder has a right. The holder has a remedy available. That is, civil law remedy is available to him. He can always file a civil suit to recover his money. The only fact is that criminal law remedy, that is 138, will not be available. So earlier, this validity period was 6 months. But after RBI notification of 2011, it has been made 3 months. Then next thing, now this is something which is very important. The third condition, the third feature is demand notice. Now, please understand this, that in general criminal law, this cause of action, it arises the moment offense is committed. All right. However, in this 138 cases, cause of action will not arise the moment check is dishonored, but certain conditions are there which must be fulfilled. Then only a cause of action can arise in 138 cases. So these are the conditions. So the first condition is demand notice. After the check is dishonored, the holder must give demand notice to the drawer, and this notice must be given by this holder within 30 days of the information, of the receipt of the information from the bank regarding the return of the check as unpaid, right? And this notice, it must be in writing. Now, if you ask me what can be the rationale behind this provision, is that first, the object is that it serves an opportunity for the drawer to rectify his error. Please understand, as I said, here cause of action does not arise the moment check is dishonored. Certain conditions are there. Please understand, this reflects that this is nothing but a civil wrong. This is nothing but a breach of contract, right? That is why Justice Rohit Nariman, in a recent judgment, while discussing Section 138, he called 138 as civil civil ship in a criminal wolf. So even he said that this is nothing but a civil wrong, but it has been enforced by criminal machinery, and that is why we have certain conditions which must be fulfilled in order to create cause of action, right? So the first condition is that demand notice. Demand notice will be given by the holder or the payee to the drawer. Then the next important rule regarding this notice is, please understand, the obligation of serving this notice on the drawer, the obligation, the burden, it is on the complainant, it is on the holder. And if the drawer is not like if he's not able to find the drawer, or if drawer is avoiding the service of this notice, then we do have a provision for presumption of such a service. So we all know service of notice, it can be of two types. First is direct service, and second is substitute service. So even the mode of substitute service is available in case of 138, where the copy can be affixed on any part of the building or office in which he ordinarily resides or carries on his business. Then please understand that giving this demand notice is a requisite, is a prerequisite in order to initiate prosecution under section 138. And now interesting question, it arose before the Supreme Court in this judgment, because in this case husband and wife, they issued a check in favor of the third party, and that got dishonored. And that third party, it means the holder, the payee, he issued a demand notice uh, only against the husband and not against the wife. So the question arose whether it is it necessary to issue separate notice if we have two or more accused, two or more uh, drawer. So the thing is that if we have two or more drawers or two or more accused persons, in that case, the court said giving separate notice to each one of them is a condition prerequisite. It is a condition, mandatory condition, in order to initiate this section 138 law, this check bouncing case, the prosecution. Then there is one more important thing regarding calculation of time period for service of notice. Please understand that these 30-day limitation period. So the limitation period for giving demand notice is 30 days. It does not mean working days only. Okay, it has been clarified that it also includes, it means calendar days, that will include public holidays as well. But if the limitation period is going to start from a day which is a public holiday, then that day should not be considered while calculating the limitation period of 30 days. That is the rule. Similarly, the rule is that if the limitation period is going to over on a day which is a public holiday designated by proper authority, then even that day should not be considered or counted for the purpose of calculating the limitation period of 30 days for giving demand notice. Now, you all must have heard about this. It is called composite notice. So please understand, uh, even a composite notice is valid for the purpose of 138. So if the parties are the same, and if multiple checks they got bounced on the same day, right? A composite notice can be given, right? Can be given. Composite notice is considered as a valid demand notice. Now, with respect to the several checks, can we file a single complaint? So the answer is yes. Okay. So even a single complaint can be filed if several checks got dishonored, if they all form part of the same transaction. So this is based on a simple rule, that the general rule is that every offense should be tried separately. But it has certain exceptions. Joint trial is permissible. Even a single complaint can be filed for dishonor of several checks if several checks if they form part of the same transaction, right? So like even a single complaint can be filed for the different checks, right? So as I said, the rule is that every offense should be tried separately, but if they all form part of the single transaction, then a single complaint can be filed with respect to the checks. Now, this is something which is very important. That is the effect of second presentment. Okay, so we are discussing the first condition, demand notice, and as I said, the limitation period for giving demand notice is 30 days, right? Now, suppose let's take a situation that your limitation period for giving demand notice is over, right? Now, what remedy you have? Suppose if you are the holder, right, and you fail to give this demand notice to the drawer within 30 days. Now, what remedy do you have with respect to this? Because after limitation period is over, you cannot give demand notice, right? So you have one option available, that you can present that check again into the bank, and if it is dishonored, right? So if it is presented for the second time, if there is that is the case of second presentment is there, then if it is dishonored again, then you can give demand notice to that person. Okay. So a complaint can be filed after a second presentment. This demand notice can be given after a second presentment. That is something which is possible. So here it is mentioned that if the payee or the holder of the check does not issue a notice, that is demand notice, he is not permitted to give notice on the check being dishonored again on its representation for collection, right? Now, the more deeper question is, can second presentment of a check, can it revive the expired cause of action? That is the uh, more deeper question, I believe. Now, please understand this. So, as I said, certain conditions must be fulfilled, then only cause of action will arise in 138 matters, right? Please understand this. So the first condition that we are discussing right now is giving demand notice. So notice must be given by the holder to the drawer for the payment of money, right? And the next thing is that after receipt of that demand notice, drawer is supposed to make the payment within 15 days. If he fails to make the payment within 15 days, then cause of action arises for the purpose of 138, and then the holder can make a complaint to the judicial magistrate first class within the period of 1 month, that is 30 days, right? So that is the final limitation period for making complaint under section 138. Now please understand this. Suppose if the holder has not made any complaint, if the limitation period for filing a complaint to the judicial magistrate first class, that is 1 month, if it is over, if it is over, if the if the if the limitation period is expired, in that case, what will be the effect of second presentment? Can second presentment revive the expired cause of action? That is the deeper question. So before recent judgment of Supreme Court, the ratio, the rule of the land, the law of the land was that second presentment cannot revive expired cause of action. So we have these two cases where the apex court said that if the complaint not filed within the limitation period after the cause of action arises, it will set the accused free, right? And the complainant has no option to defer the prosecution. But very recently, the law got changed. The rule of the law, the rule of the land, it got changed after this judgment, where the Supreme Court said there is no real or qualitative difference between a case where the default is committed and prosecution immediately launched, and another where prosecution is deferred till the check presented again gets dishonored for the same. So this judgment, it overruled the earlier cases of the Supreme Court, and it was held that the prosecution based upon second presentment of a check is also permissible, so long as it satisfies the requirement stipulated in section 138 of the Act. Now, as I said, so the third condition, the next feature is after the demand notice is given to the drawer, he is supposed to make the payment within 15 days. Okay. And if he fails to make the payment within 15 days, then cause of action arises. Then this section 138, this penal provision of 138 will come into picture. Now, so that is the rule, and please understand this 15 days is just a minimum 15 days. Okay, it can be extended. This limitation period of this 15 days period can be extended by an express contract between the parties. Okay, that is nothing wrong about it. Then next feature is that only and only drawer can be prosecuted for the purpose of 138. Right? Please understand that this offense of check is a negotiable instrument. Right? It is a negotiable. What does it mean that it is a negotiable? It means it is a transferable instrument. Right? If a check is given to you, right, it does not mean that you should present that check into the bank immediately. Okay, you can transfer that check to another person. Right? In that case, you will be considered as an endorser. That person will be considered as an endorsee. Right? And if the check is dishonored after endorsement, please understand, though there is no relationship between the drawer and endorsee, the one to whom the check has been transferred, only and only drawer will be prosecuted for 138 cases. Right? Then next feature of 138 is that just because a person has been punished, has been convicted for the offense of 138, right, it does not mean that uh, he has been convicted of an offense involving moral turpitude. So we all know this moral turpitude. It is something that, like, if a person is convicted for offense which is against the morals of the society, that is considered as offense involving moral turpitude, and this is a ground to reject your application to join any government job. So just because he has been convicted of this 138 cases, it does not involve moral turpitude at all, because as I said, this is nothing but a breach of contract, and this is nothing but a civil wrong. But it is just that to create deterrence in society, it has been made punishable. Now, as I said, criminal prosecution is not for the recovery of money, right? So for recovery of money, we have civil suit, civil remedy, and the object of 138 is to create deterrence, right? So that is why, to punish the accused person, that is the object. And that is why, please understand, if the check is dishonored, one person may initiate both civil remedy, he may exhaust both civil remedy as well as criminal law remedy. Okay, he may put civil law into motion as well as criminal law into motion. That is the thing. Then next feature. So I told you the difference between 138 and 420 of the IPC, that is successful cheating and 138 cases, as well as 138 cases and simple cheating. Please understand this, that uh, 138 cases, it does not require mensia, but simple cheating and successful cheating, 415, 420, that is our in our new criminal law, that is Bharatiya Nyaya Sanhita, it is 318 clause 1 and clause 2. There we need a mens rea to constitute wrong, but in 138 cases, we do not need a mens rea, right? Further, the conviction rate in 138 cases is high compared to the offense of cheating, because they do not have various rules of presumptions, unlike 138 cases. So please understand this. Please understand the relationship between them. The relationship is that generally when a check bouncing case, when it takes place, the prosecution, they always try to invoke 420 of the IPC, because please understand the relation. The relation is 420 of the IPC is a cognizable offense. It is a non-bailable offense. Successful cheating is a cognizable offense. Successful cheating is a non-bailable offense, whereas 138 is a non-cognizable offense. In this case, 138 cases, FIR cannot be filed. Only a complaint can be made to the judicial magistrate first class. Whereas in case of 420, FIR can be registered, right? Arrest can be made, which is absent in case of 138 matter. Further, in case of 138 matter, bail will be granted, bail can be claimed, whereas 420, it is difficult to get bail. So that is why the prosecution, whenever the check bouncing cases it takes place, the prosecution always do try to invoke 420 as well, right? That is the reason. But we should always keep in mind the difference between 138 and 415 and 420. Now let me explain this the difference through one example, through very good example. Suppose if there is Mr. A and Mr. B, and if A issued a check to B, so that we should so that B will deliver his goods to A, right? And suppose if A is not aware, he does not have any knowledge, right, regarding the fact that the funds are insufficient. Now in this case, please understand, only and only 138 will come into picture if the check is dishonored subsequently. Now let's take situation number two. In this situation between Mr. A and Mr. B, if A has issued a check to B, A is the drawer, B is the holder, and A is aware, he has a knowledge that funds are insufficient. But just to create this deception, he issued a check to B so that B will deliver goods to A, because we all know check is a conditional payment. In that case, please understand, if goods are not delivered, if that is not a successful cheating, only he tried to cheat, he tried to create a deception by issuing a check. In that case, simple cheating, 415 will come into picture, which is something punishable with 1 year imprisonment, which is something like 138 cases only. That is something non-cognizable offense. That is something bailable offense, right? And then third step is situation number 3 is if A issues a check to B in order to create a deception, he has a sufficient knowledge that funds are insufficient, but he issued a check so that B will deliver goods to him. And suppose B has delivered goods to him, and subsequently it is found that the funds are insufficient and the check got dishonored due to the same. In that case, this amounts to a successful cheating. In that case, the drawer will be charged with 138 cases, obviously, because mens rea is not required, right? 415 as well and 420 as well, right? In that case, that will be the cognizable offense. FIR can be registered along with the complaint to the magistrate, right? So that is the relationship between 138 and 420. Just because if the offense is made out in 138, it does not mean that the offense of 420 will be made, right? Please keep this in mind. Though prosecution, they always try to invoke 420 along with 138. All right. So as I said, both civil wrong and criminal remedy, they can, like, the person may exhaust both things. Now next is no offense will arise where the check is written due to the because of a technical defect, right? So if like a check can be dishonored for multiple reasons, right? So if the check is dishonored due to there's a variance in signature, variance in amount, right? Due to such a things, and if it is dishonored, then this section 138 will not come into picture, right? Then last point with respect to this dishonor of check, a blank check kept as a security. So as I said, the condition is that check must have been issued to discharge a debt or a liability, right? Now, does it mean only existing liability or does it mean future liability? That is the question. Suppose a blank check, it has been kept as a security so that a person will deliver goods in future to the to the one who issued the check. Meanwhile, before the goods will be delivered, before will this time has come, uh, this person, this holder, he presented a check into the bank. It got dishonored due to the insufficient fund. In that case, please understand, where a check has been kept as a security and it has been dishonored, right? So it has been kept as a security in order to secure future delivery of goods, future liability. And if it has been dishonored, please understand this. In that case, in that situation, please understand this, that this offense will not come into picture. Because when I said a check must be issued to discharge the debt or liability, it means existing debt, it means existing liability. It does not include future liability. Okay. So these are the features and conditions in order to invoke 138. And as I said, lastly, as I said, the after the cause of action arises in this 138 matters, uh, the limitation period is 1 month. Within 1 month, the complainant can make a complaint to the magistrate. And as I said, this is a non-cognizable offense. Here, FIR cannot be filed. Only a private complaint can be made to the magistrate. And private complaint means an allegation to the magistrate that any person has committed an offense, known or unknown. And these are the elements. These should be the elements of complaint. A complaint under 138 should contain a date of presentation of check, date of dishonored, and date of demand notice. So it must be mentioned clearly while filing a complaint to the magistrate that a demand notice has been given to the drawer, and he has disobeyed the same. He failed to make the payment within 15 days, and that is why we have this complaint before the magistrate. Now, please understand, as I said, these conditions are there because this reflects that this is a civil wrong. This is a civil ship in criminal wolf, as Justice Rohinton Nariman said. And that is why we are supposed to comply with these conditions first before a complaint can be filed. However, if the complaint is filed, right, if the complaint is filed, disregarding these conditions. So, for example, as I said, cause of action uh, arises after the statutory limit of 15 days is over for drawer to make the payment. In that situation, in that circumstances, please understand that if the complaint is filed before that statutory period of 15 days is over, it is considered as a premature complaint. Okay. So magistrate should not take the cognizance, but if the by mistakenly, if the magistrate does so, then the drawer has a right to approach to the High Court, and High Court can quash the complaint by invoking their inherent powers. They can quash the complaint. They can quash the premature complaint because, as I said, uh, to comply with these conditions of 138, it is not. It is a mandatory thing, right? Because only after the statutory period of 15 days is over, then only cause of action arises in 138 matters. So that's it for this 138. So now today we have discussed only 138 as such and the features of 138.
So should I stop recording?
Yes, yes.